I want to welcome to the program in the meantime Steve Holbrook, Second Amendment attorney and scholar. Steve, how are you, sir?
Oh, I'm wonderful, Cam. How are you?
I'm good. Thanks for coming on the program today. One of the stories obviously overshadowed by the tragic events in Boston yesterday was I guess the decision by the Supreme Court not to hear a challenge to New York State's concealed carry law. What's your take on the justice's refusal to hear this case?
Well, first of all, New York bans both open and concealed carry. Many states allow open but not concealed without a permit. And what New York does is to prohibit any kind of carry and any kind of bearing arms without a license. And the license is based on a subjective determination of proper cause by the authorities. Now, the Supreme Court has denied review of other cases of this same type before. If you remember, I guess it's been 2 years ago or a year and a half ago in the fall, I filed a cert petition in the Williams case out of Maryland, and then the Mazzandero case out of the Fourth Circuit went up, and the court denied cert in both of those cases. And the Williams case had to do with the fact that in Maryland there's no permit available to law-abiding people. Once again, it's like New York; it's discretionary. And then with the Mazzandero case, it was purely the question of whether there's any right to bear arms outside the home. But I don't put too much weight in, or I don't put any weight in the court denying review of a given topic in terms of what the law is, whether the court decision below was rendered correctly. But the Supreme Court itself has said you cannot read anything into us denying a cert petition, a petition to hear a decision from a federal or state court below it. So there's nothing to read into it. You can only speculate about what justices are thinking in terms of whether they decide to hear a case or not. So as it stands, the decision in question is called Kachowski versus County of Westchester, New York. It was decided by the U.S. Court of Appeals for the Second Circuit this year. And basically, the court, how could it? It didn't deny that there is no right to bear arms, but it simply said that the authorities get to decide whether you exercise that right.
Yeah, and the court, Steve, I mean, they're going to have other opportunities to say yes to a case if they want to hear a right to carry case, because there are a number of other cases in the circuit courts, right?
Yeah, there's the case out of the Seventh Circuit, Moore-Shepard, which basically struck down the Illinois total prohibition on carrying arms outside the home. There's not even a license or permit available in the state of Illinois. So on the one hand, that case, that decision is a robust defense of the right to bear arms. It really makes clear what the other courts try to basically hide, that there's no right to bear arms. It doesn't say it's limited to the home. And it tells you something about courts that try to limit the right. I mean, this was going on well before Heller and McDonald. You had many lower federal courts basically denigrating the Second Amendment. And I think now you have a nullification of the decisions in Heller and McDonald, basically resistance by lower courts to what the Supreme Court said. I mean, we've been through this on your program before about what the court said in Heller in terms of what the term bear arms means. The limitation of bearing arms to sensitive places like schools means that, there must be a way to, or must be a right to carry arms at other places that are non-sensitive. So there's a lot of meat in the Heller and McDonald opinions that could have been drawn on here by these lower courts that are finding adversely to the Second Amendment right.
Steve, do you think at some point, given that there is a split within the Seventh Circuit, at least as it stands right now, and these other circuit courts, and we may see further splits develop, does that increase the likelihood that the court will eventually hear a right to carry case?
Generally, that's the case where you have cases percolating like they are now, and you start to get splits, and then the splits widen. That gives the court more incentive to basically resolve the split in the circuits. There may be some tendency with the members of the court to let it be worked out in the political process or at the state level. The justices that are for the Second Amendment are also in favor of federalism, and it's possible that they certainly don't want to get into writing state statutes on the requirements for carrying weapons outside the home. And just in terms of the issue of splits, there was a suggestion in the Seventh Circuit case by the dissenting judges, or the dissenting judge, I should say, that suggested the New York scheme is what Illinois should adopt. And so how wide is the split? I mean, the New York decision here says, well, yeah, we're going to recognize the right to bear arms. But when you look at it under a microscope, there's nothing left there, because they basically say, well, just because you live in a unsafe neighborhood or a dangerous neighborhood or you work in a dangerous location doesn't mean that you have a proper cause to obtain a license to carry the handgun.
Mm-hmm.
You have to have some kind of unique reason. And, if you live in a dangerous place where it's a danger to everybody, there's nothing unique about that. I mean, what kind of reasoning is this? It's kind of crazy. But we all know how it works in the state of New York and in the city of New York. It's the important people who get these licenses to carry, and the common people don't.
Yep, exactly right. Steve, we're almost out of time, sir, but thank you so much for joining us this afternoon, and look forward to talking again very soon.
My pleasure, Cam. Thank you for having me.
You bet.